In the name of the Father, and of the Son, and of the Holy Ghost. Amen. Welcome, friends, to Crime and Punishment, a legal podcast, not a political one. This is episode 96, I believe. We're calling this Victory in Charlottesville today because there was a massive victory in Charlottesville. Not mine, but that of Jacob Dix. And I'd tell you all about it, but my computer's not loading. So, this is going to be one of those days. So, we had a trial for Jacob Dix the first full week of June. It ended in a mistrial. And that is about as good as it gets in a communist stronghold like Charlottesville. 8 people voted not guilty, which is incredible. 3 people voted guilty and 1 was undecided. I can't imagine being undecided, but that's where we're at these days, right? So, wow, what a disaster this is turning out to be. Let's just switch devices here. So one of the most important things to note about the Dix trial is that once it was all over and it was a hung jury, the prosecution asked defense counsel to go outside. They made an offer. Just tell him to plead to a misdemeanor. He'll get time served. He'll go home. This is over with. And I put in my tweet that Dix had told them in response to fly a kite. What he actually said was even more epic. His lawyer told him, "This is the offer," and Dix leaned over and said, "Never." What a stud. What a stud, this guy. So, let's go to... Oh, I never got the viral style. In any event, let's go to Emperor Invictus at Twitter. That's where we post all these articles that we're discussing. It's going to be tough to talk about the thing in Georgia. I was hoping to play the video. That's not going to happen. Did get a new computer today, so next time we will have a full production here again, like we used to. Not next week. Next week I will be in a retreat with the Catholic Church. Let's see. Oh, this goes back, huh? So there's a lot of articles on the Dix trial. Man, where should we start? There we go. Here's an excellent write-up on the trial of Dix. This is by Jason Kessler. The case of Jacob Dix, who was being charged with using fire to intimidate during the Torch March at the University of Virginia campus in Charlottesville, Virginia on August 11th, 2017. So remember, this is 7 years ago. The night before the Unite the Right rally, has ended in a mistrial after the jury was unable to come to a unanimous verdict. This was the most significant setback yet for the George Soros-backed Albemarle County Commonwealth Attorney Jim Hensley and his Antifa assistant Lawton Tufts, men who decided to pursue charges against peaceful protesters 6 years after the fact for political reasons. One of the things not noted here in the article is that both Tufts and Hensley were public defenders before this. These guys jumped ship from the defense side to take over the prosecutor's office to prosecute this case. Their political enemies, against whom Tufts himself had counter-protested on the night in question. That's not mentioned in the article. It's also noteworthy that Hensley wasn't just a public defender. He began the public defender's office there in Charlottesville. He was the public defender. And that was 25 years ago. 25 years he was a public defender doing this stuff. And just jumped ship so that he could prosecute all these Nazis. Throwing his career away. Just an absolute... Black mark is not the... You just took your career and flushed it down the toilet with this stunt. To continue, no evidence was presented that Dix assaulted anyone or used his torch for anything other than presenting the message of the political demonstration he was involved in, which opposed the replacement of whites and their history throughout the West. Now again, that's not our message here at Crime and Punishment. That's Kessler's interpretation of the trial. We are on YouTube. We do not espouse the replacement theory. This is just legal commentary. Don't kick us off YouTube. The entire case was presented as an opportunity to put Dix on trial for the Second World War and anti-Semitism, since a minority of the protesters had chanted, "Jews will not replace us." The prosecution called Diane DaCosta, who is brown but identifies as Jewish, to say that she had heard chanting from her dorm room on the UVA lawn and was afraid. Quote, "I'm literally putting sheets on my mattress and I hear a guttural, angry, rhythmic chant of 'You will not replace us,' end quote," said DaCosta. Quote, "It turned into 'Jews will not replace us,' end quote. It's unclear how one might figuratively or metaphorically put sheets on their mattress. Regardless, DaCosta went on to testify about hiding a painting of a Star of David in her dormitory. Now, I haven't seen a witness list in my case. I'm not allowed to see the evidence in my case, believe it or not, unless I drive to Maryland to go see it. So I don't know who these alleged victims are in my case. I don't know if DaCosta is a witness against me. I don't know. So I am not commenting on any of that. I'm just reading this article verbatim. Zero commentary. I have nothing to say about anybody who testified at Dix's trial. Just want that very clear for when the Antifa prosecutors try to play this in court to have my bond revoked. To continue with Kessler's article, classic cry-bully tactics, acting like a victim while begging the state to lock up your political rivals. The prosecution also called James Loeffler, a radical leftist Jewish professor from Johns Hopkins University, to testify about Nazi Germany. Needless to say, everything that happened in Nazi Germany occurred almost a century before the Unite the Right rally took place. No one at the rally, including Dix, fought in the Second World War or was a member of the Nazi Party. They were American citizens utilizing their right to protest. The testimony's only relevance was to attempt to instill prejudice in the jurors' minds against the defendant. Most unwisely of all. All right. These following paragraphs are about Gorsinski. Like I said, I haven't seen a witness list. I haven't seen any evidence, but I think we can probably surmise Gorsinski is one of these witnesses in my case. So I'm just going to pass over all of these comments on Gorsinski and go to the case was tried in Albemarle Circuit Court, but prosecuted by Henrico County Commonwealth Attorney Shannon Taylor. The reason for this mismatch was due to the explosive and rare recusals of both a judge and the entire Albemarle County Commonwealth's Attorney's Office over undisclosed conflicts. Evidence uncovered by Dix's attorney, Peter Frazier, and myself, that is Jason Kessler, not me, showed that Judge Claude Worrell and his family were witnesses to the events of the case, and his wife, an Antifa activist named Catherine Laughlin, had been publicly calling for the defendants to be prosecuted. Yeah, wow. And didn't bother to disclose that, which is incredible. Assistant Commonwealth's Attorney Lawton Tufts, who led the charge on the torch cases, was an activist for Black Lives Matter as well as Antifa groups that have been hoping to disrupt the Unite the Right protests in 2017. A juror poll revealed how the all-white jury of 5 women and 7 men voted. 8 voted not guilty, 3 guilty, and 1 was undecided. Although double jeopardy does not apply during a mistrial, and Taylor has already indicated that she will attempt to retry the case, the jury's split should cause her to rethink the wisdom of following this path deeper into a quagmire. Another potential hurdle for a retrial is a motion hearing scheduled for August 22nd. Attorney Frazier filed a number of motions to dismiss the charges prior to trial. Judge Patrick ruled against some, but 3 are still active, including one arguing the unconstitutional vagueness of the charges against Dix. So, let's unpack that, decipher that a little. So on August 20th, so this trial was the first full week of June, right? Ended in a mistrial. Now, at the end of the trial, that's when the prosecutor offered, look, just take a plea to a misdemeanor and let's get over with this. And Dix said, never. So they set a hearing for August 22nd. Why did they do that? Because Frazier had filed several motions to dismiss before the beginning of the trial. The judge had dismissed, I don't recall the number, one or two maybe, dismissed a couple of these motions, but then kept certain of them under advisement. One of them being the vagueness of the statute. Now, what that means is that there is a constitutional requirement that these laws that we're all held to, they have to be specific. You have to say what is specifically prohibited. We've talked about that on this program many times, about when we were all growing up in the Cold War, the difference between the American system of government and the Soviet system of government is that in America, under the Anglo-American tradition, you have to specify what is prohibited. And if it's not specifically prohibited, you are at liberty to do what you want. Under the Soviet system, at least from our perspective as Americans during the Cold War, their legal system was, yeah, well, you should have known that this was illegal, given this statute, and we can interpret this so that, we don't like your conduct, and we're going to interpret it under this statute. And that's exactly what American law has become. Federal, state, and local levels. They will dust off some crazy old law from 150 years ago that nobody even knew about, and they'll say, yeah, we're going to charge them under this statute because we can. Because it's illegal. You don't even have to know it was illegal. You don't even have to have a reasonable suspicion that it was illegal for you to engage in that conduct. They will dust off that law and they'll say, we're going to interpret this in this way. Kind of like what they're doing with J6, where they had these laws passed after the Enron scandal about destroying documents, and now they're saying, well, you held up a session of Congress, we're going to use that statute against you now, because we're going to interpret it in this completely new and different way. That's what is happening in Charlottesville. We're going to take this law that was based on burning crosses by the KKK, which, was seen as illegal. So then it was overturned, but then the Supreme Court said, no, you can do that because, burning crosses is inherently an intimidation tactic, which is dubious legal reasoning on this part of the Supreme Court. But while all that was going on, Virginia said, well, if we can't say burning crosses is illegal, then let's just make a statute that says burning an object with the intent to intimidate. Now that will be a felony. Obviously, that means burning crosses or setting something on fire to intimidate people. Like you think of the Malcolm X movie, right? And think of Malcolm X as a boy, the Klan rides by and burns down the house and says, you better get out of here, get out of town, you're not welcome here. That's burning something to intimidate someone, right? Or riding up on their lawn, putting a cross on the lawn, and then setting that on fire and saying, get out of town. That's what burning an object with the intent to intimidate. That's obviously what this law was all about. But you have these activist prosecutors, they weren't even prosecutors, which is, part of the case. These were University of Virginia law professors, public defenders, by the way, in their spare time. University of Virginia law professors and legal staff who said, well, wait a minute, we've got this statute that we could use against these Nazis who walked through the University of Virginia and we don't want them here. The people whose political speech we disagree with, we're going to dust off this statute that has literally never been used in Virginia, right? And that was passed because there was this constitutional dispute about the burning crosses statute. We're going to use that and we're going to prosecute our political enemies with it. And the prosecutors said, no, what they have done is not against the law. That was protected free speech. So then what do? They say, well, you won't prosecute it. We're going to take over the prosecutor's office and we are going to prosecute it under our, twisted theory of law. That is what vagueness means. That is unconstitutional. When you can take a law and make it mean all these different things and nobody knows what it really means to burn an object and nobody really knows, who's going to be prosecuted for what conduct, that's unconstitutional. That law cannot stand in the United States. So having explained that motion is going to be decided on August 22nd. If the judge dismisses the case, well, great. That is a total victory. It's over. If the judge does not dismiss the case, then that's why Kessler is saying, well, what is the wisdom of bringing this case again? Because without an acquittal, the prosecution can retry the case. If you are found not guilty by the entire jury, if there's a unanimous verdict saying, no, he did not commit this crime, double jeopardy attaches. You cannot charge that person with a crime on these facts ever again for the rest of their life, period. However, if there is a hung jury, the prosecution can take you back a second time. They can take you back a third time if there's a hung jury. Only if there is a conviction or an acquittal, unanimous, is it over. And of course, if you get convicted, then you would appeal. And obviously there's a legion of appealable issues in this case. But that's what Kessler's talking about. On the 22nd, those motions will be decided. If the judge says, nah, I'm just going to let this go, it's not unconstitutional, well, then the prosecution's going to have to decide, is it worth being humiliated yet again with a hung jury for this nonsense? So, back to the article. Judge Patrick ruled against some of the motions to dismiss, that is, but 3 are still active, including one arguing the unconstitutional vagueness of the charges against Dix. Here are some excerpts. Quote, the law has no precedent in English common law. Dix and his co-defendants are the first people ever charged under this law. Section 18.2-423.01 has at least 2 fatal defects that render a common man unable to know what conduct it prohibits. 1, it is unclear what it means to, quote, burn an object in this context. And 2, it is unclear how one with the intent to intimidate uses a burning object to put someone in fear of death or bodily harm. As applied to our case, the statute is too vague to inform a common man whether carrying a tiki torch in public violates the terms thereof. End quote. The defense might have preferred for Judge Patrick to rule on the constitutionality of the charge before trial, but he declined to do so. Now that he has seen the scant evidence presented against Dix, he was literally merely standing still with a lit torch, and the unwillingness of a jury to secure a conviction, perhaps Patrick will be more likely to end the legal process before more time and money are wasted on a retrial. I spoke with Dix by phone, that is Kessler, not me, and his spirits are high. He recounted a story demonstrating the prosecution's growing desperation. After failing to secure a verdict, they offered Dix a plea deal to take a misdemeanor with time served. Dix turned them down without a second thought. Like I said, he leaned over and said, never. If we ever get a filmmaker on our side of the fence, this has got to be a movie. And that's got to be the climax of the movie. Dix's attitude is valiant, yet sober. Oh, excuse me, I missed a quote here. Dix said, quote, I would rather have a felony record than give them permission to go after 300 of my comrades for peacefully protesting, end quote. So that is another aspect of this whole circus, right? The Antifa prosecutors who took over the prosecutor's office to charge all of us with this thing, their theory of the case has always been, well, these guys surrounded a statue. Right? I won't get into the ins and outs of how fucking retarded that is, but that's been their theory of the case. They surrounded a statue, they intimidated these people, they were in fear, right? Well, when the special prosecutor took over, these people who were not the Antifa who took over the prosecutor's office, but these out-of-county prosecutors who came into town to do this, they changed the prosecution theory completely and essentially said everybody in the town of Charlottesville is a victim. Everybody was intimidated by this walking with a tiki torch, right? And not only that, but even though we're not charging these guys with conspiracy, we're going to say that the jury should be instructed on concert of action, which means that you should have known that your actions would lead to this crime by other people, by the whole group, right? Madness. So that's what Dix is saying when he's saying, I would rather have a felony record than give them permission to go after 300 of my comrades for peacefully protesting. Because it's not just the people who surrounded the statue, right? If you go with that prosecution theory. No, it's every single person who held a torch at that rally. So 300 people are now on the chopping block. Like, this nationwide J6 dragnet, right? Which they've done in Charlottesville to just a lesser degree of magnitude. A lesser order of magnitude, excuse me, where they just, they get people in Utah, Vermont, Florida, Texas, all over the place, drag them back to Charlottesville, hope to have them held without bond so that they will plea. They want to do that to all 300 of those people that were there that night, almost 7 years ago now. That would be the result, the logical result, of going with that prosecutor's theory of the case. So Dix, this stud of a hero, said, I'd rather have a felony conviction than give them permission to go after these people. Because if Dix had taken a plea after that disaster of a trial, if he had just caved and been like, dude, I don't want to go through this anymore. I'm tired of this. I just want to go home. If he had folded like that, that would have given the green light to these prosecutors to say, well, let's go after everybody now. Every last person we can identify. So any of you there that night, you should be sending this man a thank you card, because he just saved all of you from this unjust prosecution. Dix's attitude is valiant yet sober. It's true that prosecutors have been preying on men without hearts for risk or struggle, willing to plead guilty to things they didn't do, rather than risk jail time and legal expenses. Many of the guilty pleas came after bond had been denied to men with no prior criminal records by the conflicted and recently recused Judge Worrell. Dix is the first man with the bravery to face the risk. He is the bulwark against the government merely steamrolling every man who attended the August 11th protest. I will say, I disagree with Kessler in this respect that, and I think he ends the article too with don't plead to things you didn't do, or maybe he said that on Twitter. Having been in jail a considerable amount of time myself over the past several years, and having seen men whose lives are completely destroyed by being there, I get it, man. I get why people enter plea deals when they cannot get bond. Like I've seen men, their entire lives fall apart, not just their lives, but their kids' lives, their families. They lose their truck because who's going to pay for it, right? Can't get their kids to school. Who's going to take them to school? The junkie mother that they have to deal with. They get sent to, I've seen guys whose kids go to freaking foster care because they're locked up in jail without bond. Sometimes on totally false charges. Sometimes, yeah, they did it. But sometimes they didn't. And their lives and their families' lives are destroyed by this. And I've seen so many guys in the considerable amount of time I've spent in jail without bond take pleas to things they didn't do, or at least they didn't do to the degree that the state alleged, because they just got to get out of there. They've got kids depending on them. They've lost their jobs while they've been there. They got to put their lives back together. Their cases are not political. Like their cases are just nothing heroic can come of it. So they'll take those plea deals, and I 100% get it now. So I disagree that in all cases you shouldn't take a plea. Like it's a game for young men who have nothing to lose, I guess. But if you got kids and you got people depending on you to get out of there, sometimes, man, those guys will take pleas, and I get it. Dix's case was and is the bellwether for all others. Oh, and the reason I was bringing that up is because it's my understanding that these guys who did take pleas in Charlottesville, whether they had criminal pasts or not, and I think several of them did not, as Kessler mentioned, they had families. I mean, one guy was from Texas, had like 10 kids, and he's going to wait in jail for 5 months minimum, because that's the statutory time for your speedy trial in Virginia, as I understand it. He's going to wait there for 5 months. His wife's home with 10 kids. Like, what are you supposed to do with that? How do you not take a plea to that? So like I said, man, I get it. I do not hold that against these guys. Dix's case was and is the bellwether for all the others. He has the best chance to beat it, too. The indefatigable defense of attorney Frazier and Dix's striking good looks and friendly disposition represent an uncharacteristic surprise coming from a movement of mostly dour men who have been forced to endure smears and unjust persecution from the law for their political ideals. Yeah, I'm pretty dour, I guess. In this context, a mistrial is absolutely a victory. Not a total one, but it is a significant political, logistical, and public relations defeat for prosecutors with designs on arresting hundreds of nonviolent marchers in order to appease cry-bully left-wing activists. And that's the article. Great write-up, great explanation. I would post the link for you, but again, my computer is acting really crazy. That's why I had to buy a new one today. So just go to Emperor Invictus at Twitter, and that's where I post all of these articles that we talk about. So let's go to the chat. Tampa Vikings, what's up, man? John Gordon Mead, hail. Doom Paul, what's up, man? 12-pack. I just received Jason Kessler's book, Charlottesville and the Death of Free Speech. Oh, I did too. I got it, and I left it at home. I thought I had it here at the office, but I was flipping through it, and I saw there was a paragraph about me, and it said something to the effect of Invictus. Invictus was probably the most normal and likable of all the speakers at Unite the Right. Oh my God. That might be the funniest thing anyone's ever said about me. Certainly one of the nicest things anyone's ever said about me. Calling me normal and likable is like the last thing I ever expected to see in print. God bless Kessler. Shovelhead, good afternoon, buddy. CB Robertson, what's up, man? Hey, I got your text. Completely forgot to text you back. I had texted you about Happy Easter. I'm going to get back to you, man. I was going to reach out to you about something else last week, too, so I'm going to have to get back. I'm going to figure out what it was I was supposed to text you about earlier this week, and I'm going to get back to you. Garfield but racist. How's it going, buddy? Tarsterkuz. Dix is a fool. He should have taken the deal. I would have. I don't even know what to say to that, man. That's nuts. Dix saved everybody from these frivolous prosecutions. Everybody that hasn't already been arrested, of course, or hasn't already had a secret warrant issued, after this nonsense by the grand jury. Like, obviously, all of us are still on the chopping block, but there are hundreds of people there that these prosecutors would go after if they thought they could get away with it. It's like you got a bully at school, and the only way you can stop the guy from bullying you is to stand up to him. Like, if Dix had said, yeah, okay, and this is what I tell my clients too all the time. Now, this is a legal commentary program, not giving legal advice. I will say some people I give advice to, I tell them, look, man, you can't take a plea deal, because if you take a deal to this, they're just going to come after you later. And then you're going to have this mark on your record, and then they're going to say, well, we got him that time. Now he has a criminal record. And now any accusation we launch against him is going to be true. So, I've got so many clients, man, who they're like, man, I took a plea to this marijuana thing like 20 years ago, and it wasn't even true. But then, I got charged with a DUI, and they're like, well, you had the marijuana charge. Of course, you're guilty of the DUI. And it's just like this, like, once you're trapped in the system and you've admitted to this crime, it's over for you, man. Like, you're a career criminal at that point. Now, I do know some people who, they get mixed up in something, they take a plea, they go through probation, they complete it successfully, they're model citizens, get it expunged, and it's over. It's done. I've had, I won't say a lot of clients like that, but several clients like that who are just absolutely model citizens, did everything right, they were perfect angels, and they go on with their lives. But that's not the majority of people that are being sought after by the government. A lot of people have these questionable activities. They're into women, or they drink, or they're into politics, God forbid. And once you have a conviction, they're after you for life, man. Even if you don't have a conviction, you get enough accusations, they will think, well, where there's smoke, there's fire. So I really, God bless Dix. I really don't think he had an option but to say, no, go fly a kite. Because if he had said, yeah, okay, I admit to this and I'm going to take a plea, then, well, what about August 12th? There's no statute of limitations in Virginia. Why not charge him with that next? You've already admitted to this August 11th thing. We know you're not going to fight. So now we're going to charge you with your conduct on August 12th. Whatever that may have been. So yeah, Dix is a hero. I would strongly disagree with that statement, that he is a fool. Robertson's asking, isn't burning a tiki torch using it according to its intended use, and therefore not burning in any sense that could possibly be interpreted as intimidation? Yeah, that's a very good point. The entire purpose of having a torch is that it gives off light. It emits light, right? Obviously, the legislative intent of the burning torch or the burning object statute was, like I said, burning crosses, setting something on fire in order to intimidate someone. That's what burning objects means. Burning an object with the intent to intimidate. That is the language of the statute. But the fact that it can be interpreted now, because of these liberals in Charlottesville, it can be interpreted as, well, you flick on a lighter and somebody's intimidated. Well, my God, you've just committed a felony. Right? So I agree with you. What if you're like, you know how you tell spooky stories and you put the flashlight up to your face? Like, what if you have a candle and you hold the candle up to your face and somebody finds it scary? Have you now burned an object with the intent to intimidate that person? It's madness. Obviously, that's not the legislative intent. Both prior prosecutors before Hinchley took over said that's obviously not what the statute is. The Heafy report, Heafy said the same thing. That's not what this statute says. If you want it to say that, then you got to change the law and say it's illegal to carry open torches, right? Nuts. Good afternoon, Brian, from the East. Tars Tarkus. Oh, Tars Tarkus. Oh, the John Carter, Princess of Mars, Edward Burroughs guy. Yeah. He says, I certainly appreciate what you said, but I don't think you can ever get an acquittal in Charlottesville. Well, I agree with you there. I agree. An acquittal in Charlottesville would be a miracle. I think everybody knows that. Obviously, the prosecutors know that. They're banking on everybody in Albemarle County who will be called for this thing being already so prejudiced by the Unite the Right rally that they're going to convict for whatever. Now, if they had brought this charge 5-6 years ago, then yeah, that probably would have been the case. That fucking mob in Charlottesville would have convicted anybody for anything if you put them on trial. But now, it's not just Charlottesville. Like, the jury includes Albemarle County, so you would think there's got to be someone with, like, common sense outside of the city limits of Charlottesville. But yeah, you're never going to get an acquittal because you will have Charlottesville people, you will have liberals, you will have people who are Antifa, who are lying to get on the jury, and that's what they're banking on. Can they get 12 of them, though? I'm skeptical of that. But as far as getting an acquittal, yeah, I'm with you. I don't believe that either. I don't believe I'll get an acquittal, quite frankly. Not because I committed a crime, but because they are all fucking communists in Charlottesville. So I get what you're saying there. Storm Hunter says, I lived there for 7 years, and I don't think so. Yeah. Yeah, I think everybody's skeptical about an acquittal. It's just going to be a war of attrition, How many times will the prosecution retry this case? At what point are you going to wear the defendants down enough to just take a plea and go away? Freedom Falcon. Been a long time, buddy. Good afternoon. Will you do a stream on the oral arguments for the government's appeal of the Rundo case that happened yesterday? Yes. I watched it live. I had a friend capture it download it from where I guess they've streamed to YouTube. I watched it on the court's website, but they also stream it to YouTube, and I guess that's embedded. Anyway, yes, I have a copy of it. I want to wait until the judges come back with their opinion, and I want to play the oral arguments. I think I've already read through the pleadings in previous episodes of Crime and Punishment. So I want to play the oral arguments for you guys that missed it, and then go through the judge's opinion whenever it does come out. And then we're going to have an episode just on that. So who knows how long it's going to take for the court to make a decision. In brief, spoiler alert, it was extremely biased, to say the least. So I can't imagine them taking a whole lot of time to come out with a decision unfavorable to Rundo. But as soon as it does come out, we will do an episode just on that. Hey, guy whose name I assume is a profanity. What's up, man? Good to catch you live. Back at you, man. Good to see you here. Robinson says, someone should introduce the fine people hoax as evidence for prejudicing the entire jury pool. Dude, there are so many things. So many things. Like the fact that the street outside the courthouse is named something like Heather Heyer Road. Like, obviously you cannot get a fair trial in Charlottesville, period. There's just no question. Nobody could say with a straight face that you can get a fair trial in Charlottesville if you're accused of being to the right of Karl Marx. So let's go back to the internet machine. Let's see if it's working yet. Let's see. Twitter.com/Emperor Invictus. We got 15 minutes. Yeah, it's not working. Let's go back to the other device here. I was going to talk about this thing that happened in Georgia, but I do want to play the video for you guys, or at least the audio. So I might just wait till the next episode to do that, but it's wild. Ursula Haverbeck is again facing prison for her political speech. This time for a new trial for inciting hatred at the age of 95. You might recall her as the Holocaust denier. She's 95 years old. They're trying to put her in prison again. So a lot of people are outraged about these prosecutors came after everybody in Charlottesville 6 years after the fact. Like, what's wrong with these people? Don't they let things go? Like, you do realize these are the same people who will prosecute somebody in their 90s for having been a secretary for the Nazis, right? Like, these are the people who raised billions of dollars to hunt Nazis in Argentina. The same people. You're never going to get some kind of rational response from these people, or sense of due process or fairness or anything of the sort. Like, they are fanatics. This is a religious cult for them. Haverbeck appeared in a courtroom in Hamburg on Friday. That is Friday the 7th. This is old news. And was said to have been escorted by members of the Forensic Medical Service due to her advanced age. If convicted, she could face up to 5 years in prison. This, by the way, is the Justice Report. You can find that at justicereport.net if your internet admin will let you view it. Unwavering Holocaust denier Ursula Haverbeck is once again facing prison time for her political speech, this time in a new trial for inciting hatred at the age of 95. Haverbeck, smeared as a Nazi grandma by the mainstream press for numerous criminal convictions for questioning Jewish narratives about the Second World War, has been lionized by nationalists as a political prisoner. The current case against her stems from alleged comments made in a televised interview during the trial of Oskar Gröning, a former member of the Schutzstaffel, in 2015. Oh, interesting. Prosecutors claimed Haverbeck said that Auschwitz, famous for its wooden doors and swimming pools, was merely a labor camp. I'm unclear as to whether he's saying that the televised interview was in 2015 or whether the trial of Oskar Gröning was in 2015. And her comments were more recent. I don't know. Let's read on and find out. Haverbeck has also denied that so-called mass extermination occurred at Auschwitz. While the septuagenarian was previously sentenced to 10 months in a German prison for this crime, she was able to file an appeal and avoided immediate arrest. Haverbeck appeared in a courtroom in Hamburg on Friday, again that is the 7th of June, and was said to have been escorted by members of the Forensic Medical Service due to her advanced age. If convicted, she could face up to 5 years in prison. History of defiance. Haverbeck became a notorious figure in radical politics for her repeated convictions for questioning the Holocaust. Haverbeck has been convicted to prison numerous times since 2015, from statements to written articles that deny the Holocaust. Due to the German appeals process, she has not spent any jail time yet. In 2016, she was convicted for articles written in Germany's Voice of the Reich newspaper, where she denied the Holocaust. 1 month prior, she was sentenced to 11 months for incitement to hate, and in 2016, she was sentenced to another 8 months for similar offenses. In 2009, Haverbeck was found guilty of offending Charlotte Knobloch, then president of the Central Council of Jews in Germany, who advocated censorship. In an open letter, Haverbeck wrote that Knobloch shouldn't interfere in German domestic affairs. If Knobloch does not like it in Germany, then she could return to her origin in Inner Asia. And, quote, "You do not have to live in Germany, in this evil land where, as you say, 6 million of you were gassed," end quote. The big picture. The German people have long faced stifling government persecution and other outrages stemming from a perceived sympathy for the Nazi era and its figures. Due to a series of strict hate speech and anti-fascism laws that enshrined in post-war Germany, denial of the Holocaust or its trivializing is considered a crime if it is done at a meeting or in public in a way that is likely to disturb the public peace. So, that's an important distinction. That's how people get away with it in America as well. Well, we're not criminalizing speech. We would never. I mean, this is America. You have the constitutional right to the freedom of speech. No, they were carrying these torches in public, though, okay? And they intended it to be like a Nazi march. So that's intimidation. That's a violent crime. We would never, ever prosecute them for just exercising their free speech. Heaven forbid. No, it's the way they did it in public and intimidating people. That's the crime. So that's coming here to America real soon. Questioning the Holocaust is going to be just the same. I have a case right now where, well, yeah, okay, you have the right to wave flags and you have the right to, voice your political opinions, but you didn't ask permission of the person who owned the overpass. So that's a crime. Or the Jewish House representative who was instrumental, I should say, in passing this law. Obviously, he wasn't the only guy in the legislature, but the guy behind it, let's say, he said, this isn't about free speech. This is about intimidation. You put up a swastika. I mean, that's an implicit threat to Jewish people and everybody who's not a Nazi. It's not that you're exercising your freedom of speech. It's that you're threatening people by saying these things, because obviously people are going to interpret it as a threat. That's where we are now in America. Our ancestors are laughing at us. In April, to continue the article, 4 Germans were arrested for merely leaving flowers on the window recesses of Adolf Hitler's childhood home in Austria. The historical building was converted into a police station in order to deter nationalists from turning it into a pilgrimage site. In January, Germans in the city of Dresden faced accusations of neo-Nazi after a commemorative inscription honoring those killed during the Allied firebombings during the Second World War was unceremoniously sanded away. So, for a long time, we in America have been looking to Europe and being like, man, what is wrong with you guys? Thank God we live in the land of the free, where we've got free speech. This could never happen here. We can't get prosecuted for things like this. And then hate speech laws came into being. And people are like, yeah, well, that's different though, because I mean, you are attacking like this, protected class, and that's constitutional because you can't do that. Egalitarianism, this and that, and democracy, of course, and it's hateful and it's a violent crime. So we're just enhancing your sentence because of your intent. It's not like we're criminalizing your political views or your racist, evil ideology. No, heaven forbid. We would never criminalize your political ideology or infringe upon your free speech. But, this shows the intent you had when committing the crime. And so we're going to enhance the penalties for that crime. That's where we started. And you can see now we're at the point where, no, actually, you're flying a swastika flag. That is intimidation. That is a violent crime. You're flying a fascist flag. That's a violent crime. You're intimidating people. We're getting very close to the point where you fly an American flag or say Christ is king and you're committing a hate crime because it's implicitly violent toward Jews and minorities and everybody else who's not a white Christian American. So it has been I can't say a long slide. It's been actually head-spinningly fast, this slide into our European concept of what speech means. But here we are. We're there, man. We're there. Let's go back to the chat here. Any thoughts on James Sexton, the divorce attorney who's been making the rounds in the podcast sphere? I have no thoughts on that person, Mr. Robertson, because I have no idea who that is. With all due respect to Mr. Sexton, I have no idea who that is. But send me something, man. I'll check it out. Melody says, 95 years old, he can't find something better to do. Yeah, there's no crime in Germany. I don't know if you know that. The only crimes occurring in Germany are, old grandmas talking about the Holocaust. There's no rape, no murder, no theft, no illegal immigration. There's nothing going on in Germany. It is like a Wakandan utopia, except for these white supremacists denying the Holocaust. Can't have that. John Gordon Mead says, moral of the story for today. Once again, these hats, these funny hats, hate us. I don't know what that means. I can't decipher that. Certainly not on YouTube. Storm Hunter says, everything is a projection. Bearson Jeterix is laughing at something. I hope it's a joke I made. Leo says, we're already at that point. It's Orwellian. Yeah, 100%. The trippy part about Orwell? Guy fought for the communists in the Spanish Civil War. Between Franco and the nationalists on the one hand, and the freaking communists who call themselves Republicans. Orwell was on the communist side. His assessment, I'd say, of this totalitarian government wasn't communists. It was fascists. Talk about, somebody said everything is Storm Hunter said everything is a projection. Like, that's probably the pinnacle of projection right there. Writing 1984 about fascists when you are a communist. And it's now come to life because of these Marxists. That is the ultimate projection. Stormhunter says, did you see the drama in the courtroom of that rapper when the judge put the defense attorney in contempt? Yes, that's what I was talking about earlier. I was looking for the video so I could play it for you guys. The rapper in question is Young Thug. His attorney is Brian Steele. This happened in Atlanta. Same place, same district attorney that's going after Trump, Fannie Willis. The same district attorney who was called out for having a relationship with the person she appointed as a special prosecutor. And I mean romantic relationship, where they're spending taxpayer money that's being paid to him so that they can go on these luxury vacations. Same place in Atlanta. So this judge had an ex parte meeting, which means defense counsel's not invited, right? With the prosecutor and a witness in the case. And allegedly, I wasn't there, but the allegation is that the judge was threatening this witness, if you don't testify against this guy, I'm going to hold you in contempt. So the defense attorney called the judge out on this in open court on camera, saying, you had a meeting in chambers, ex parte, with the prosecutor and the witness. And the judge's concern is, how did you hear about this? And the attorney says, I'm not going to answer that. And he says, you better answer it. I'm going to hold you in contempt. And he says, attorney work product privilege. I'm not answering that. That's privileged information. And the judge's concern is, how did you get this information? Doesn't deny that it happened, because it absolutely happened. And he sentences the lawyer to 20 days in jail. He's going to serve that over weekends. But then one of Trump's lawyers, or a Trumpster lawyer, I'm unclear on this lady's pedigree, but she came and filed an emergency appeal, and he's not going to jail. But I wanted to play that because the corruption is so blatant and brazen. And it's all over. It's not just Atlanta. It's everywhere now. Judges are out of control. Prosecutors are out of control. Cops have always been out of control. I've been on about that for years. But the legal profession now is so debased. But we'll talk about that next time. We are out of time. Like I said, I've got the retreat with the Catholic Church next week. So the week after that, we'll be back. Try to play that video. We'll talk about the Rundo case whenever that opinion comes out by the appellate panel. Storm Hunter says the reason the downward slide is head spinning fast is because people are starting to piece it together and ask questions. Yeah, but now they're really accelerating the program because of that. Robertson says, to be fair, he became an opponent of communism, that is Orwell, after experiencing it firsthand. 1984 and AF were about Animal Farm, that is, were about Soviet communism. Oh, well, I'm going to look into that. Maybe I talked out of my hat. Mr. Robertson often corrects me, so let me look into that. We'll just assume Mr. Robertson's right for as many times as he's corrected me in the past. So maybe Orwell did come around and figure out that communism was the problem. Storm Hunter says the judge was so bent out of shape it was pretty funny watching him squirm. Not funny watching him abuse his power. Yeah, it's a heck of a video. So I'll play that next time. For now, we are out of here. What can I say? Everybody's out of school, so I can't say stay in school. I guess don't do drugs, and let's cool it with the anti-Semitic remarks.